Thank you very much. Good morning. Thank you, Ray, for that kind introduction. I'm very happy to be here for what I understand is the 32nd Annual National Institute on White-Collar Crime. Ray mentioned to me last night that the first conference back in 1986 or so was just 6 people sitting around a conference table. So you've come a long way, and I'm very happy to be here with you. First of all, it's about the farthest you can get from Washington, D.C. and still be in the continental United States. And it's good for the soul to get out of Washington, D.C. every once in a while. So I'm very happy to be here. I understand some of us may have trouble getting back. So my wife called and said there's a windstorm in Washington, D.C. I said, well, what else is new? And she said, no, seriously, it's a literal windstorm this time. The city is shut down, the government is closed, the schools are closed. So hopefully those of us who are from that area will all make it back. But I appreciate those of you who stuck around to be with us this morning. My first white-collar crime seminar was about 15 miles from here, and 27 years ago, I attended a corruption seminar in La Jolla shortly after I joined the Department of Justice in 1990. A few years later, the department built the National Advocacy Center in South Carolina, and we stopped scheduling our conferences and vacation spots, but I'm glad that you have not stopped because it's very nice to be here in San Diego. The most important reason I'm glad to be here, as Ray adverted to, is that I've gotten to work with so many of you over the past 3 decades. In fact, I've worked for many of the people in this room over the past 3 decades, and so I very much appreciate the opportunity to meet with you this morning. I've served under 9 attorneys general. So when I walk the Department of Justice on every floor, there are reminders for me of heroes, mentors, and friends who have worked there. They taught me over the years that the Department of Justice stands for the principle that every American deserves the protection of the rule of law. Our friends deserve it, and our enemies deserve it. They deserve it whether they are innocent or guilty. They deserve it whether they are rich or poor. They deserve it whether they are Republican or Democrat. And that requires us in the department to be faithful to the pursuit of truth. For lawyers, truth is about credible evidence, not strong opinions. Many people sincerely believe things that just aren't true. In the words of a 19th century Philadelphia doctor, sincerity of belief is not the test of truth. People who seek the truth need to avoid confirmation bias. They must remain open to the possibility that the truth may not match their preconceptions. Long before he became president, John Adams was a trial lawyer who proudly defended unpopular causes. Back in Maryland, our Federal Bar Association gives an annual John Adams award to a defense attorney who best exemplifies the principles of the president. Adams famously observed that facts are stubborn things, and whatever may be our wishes, our inclinations, or the dictates of our passions, they cannot alter the state of the facts and the evidence. For lawyers, pursuing the truth means always yielding to facts, even if they run contrary to our expectations. Sometimes people look at the high criminal conviction rates in our federal courts and mistakenly assume that the job is easy. You all know that the opposite is true. Conviction rates are high because federal prosecutors exercise great care before they allege wrongdoing. In Robert Bolt's brilliant play about Sir Thomas More, A Man for All Seasons, there's a humorous scene that illustrates the need for solid evidence. More and his family are discussing whether or not More should prosecute a man that they do not like. And Moore's wife says, "Arrest him." And Moore replies, "For what?" Moore's daughter provides a reason. "Father, that man is bad." And Moore responds, "There's no law against that." And Moore proceeds to explain that as a judicial officer, he must be concerned about what is legal, not merely what people believe is right. What is right is a matter of personal opinion. What is legal is an objective issue of fact and law. Even then, we do not prosecute every violation of the law. Discretion is inherent in law enforcement. Judge Richard Posner, who recently retired, put it this way. He said, "The Department of Justice wields enormous power over people's lives, much of it beyond judicial or political review. With power comes responsibility, moral if not legal, for its prudent and restrained exercise, and responsibility implies knowledge, experience, and sound judgment, not just good faith. The point is made more concisely in a remark attributed to French Enlightenment philosopher Voltaire: with great power comes great responsibility. If the quote sounds familiar, it was also said by another legendary figure, Spider-Man's Uncle Ben. The government officials who exercise discretion, as we all do in the Department of Justice, we have a special responsibility to make the right choice and base our decisions on articulable reasons. That requires experience, good judgment, and wisdom. Now, most of you have spent many years working in and around the Department of Justice. I hope you all see it the way I see it. When I walk the stately halls of Main Justice, I'm reminded that giants like Attorneys General Robert Jackson, Edward Levy, and John Ashcroft confronted the challenges of their era in the same rooms where Attorney General Jeff Sessions and I deal with the issues of our time. The Jackson, Levy, and Ashcroft portraits hang proudly in the deputies' conference room, and they're a source of comfort and inspiration to me. The portraits also are a reminder that controversy is part of the job. Department officials in the Jackson era navigated World War II. Levy presided in the wake of Watergate. Ashcroft dealt with 9/11. Those were very difficult times in the department. Now, for me, it's not just the department leaders, the famous department leaders, who are an inspiration. My personal heroes include men and women who demonstrated a steadfast commitment to the rule of law, but never ascended to the top leadership positions in the department. The conference room on my hallway on the 4th floor is named in memory of David Margolis, who many of you knew. David served as a career prosecutor for 50 years, and I was fortunate to know him for about half that time. David enjoyed telling stories about the things department officials did wrong over the years. I pledged not to repeat any of those mistakes, and now I try to pass that wisdom on to new department officials. Attorney General Sessions shares that commitment. He spent 14 years working in the U.S. Attorney's Office and then 2 decades overseeing the department as a senator. You will not always agree with our policy decisions, and you definitely won't hear this on cable TV, but I can assure you the department leadership team appointed by President Trump is very strong on ethics and professionalism. History will reflect that the Department of Justice operated with integrity on our watch. I'm very proud to work with that team of professionals in Washington. Priorities change, but federal law enforcement principles are timeless. We will defend the principles, and we will pass them on to future generations. The rule of law is not just about words on paper. The rule of law is about the character of the people charged with enforcing the law. Any nation can adopt a good constitution and reasonable laws. The question is whether people will faithfully implement them. Abraham Lincoln said that the rule of law should be the political religion of the nation. The goal is to enshrine reverence for the law in the hearts of the people and not just in the law books. In the play that I mentioned, Thomas More defends the rule of law in argument with his son-in-law, William Roper. Roper is angry because More says that he would respect the rule of law even for the devil himself. Roper insists that he would cut down every law if it were necessary to destroy the devil. And More replies, "Oh, and when the last law was down and the devil turned round on you, where would you hide, Roper? The laws all being flat." And More concludes, "I would give the devil the benefit of the law for my own safety's sake." As I reflect on the accomplishments of the Department of Justice over the past year, I'm proud of the remarkable dedication of our attorneys at Main Justice and the 94 U.S. Attorney's offices, of our superb FBI and other law enforcement agents, and of the support staff and professionals who make our work possible. What you hear about on the news is a very small fraction of the tremendous work performed by our 115,000 employees throughout the country. We are aggressively pursuing crimes that present imminent danger of harm, including terrorism, gang violence, drug trafficking, child exploitation, elder abuse, human smuggling, and countless other violations. And we remain steadfast in combating financial fraud and corruption. In 2017, Main Justice Fraud Section prosecutors convicted 234 individual defendants. The section also concluded 10 corporate resolutions. The 2017 results exceed the prior year, both in the number of convictions and in monetary sanctions. Those numbers reflect the seriousness of those particular cases. But our department will not employ the hammer of criminal enforcement to exact unfair settlements. We must always be guided by the rule of law, transparency, fairness, and parity. And we are committed to finding effective ways to deter corporate fraud and ensure that individual wrongdoers are held accountable. One aspect of that goal is to punish the people who make or knowingly participate in decisions that violate the law. And the corollary to that is equally vital. We want to avoid imposing penalties that disproportionately punish innocent employees, shareholders, customers, and other stakeholders. Corporate misconduct can be, and often is, serious or pervasive enough that an entity-level criminal resolution is warranted. And we will pursue that outcome when appropriate, but we think carefully about accountability and fairness in our decisions. Now, let me highlight some of the accomplishments of our white-collar enforcement efforts. Many of you are familiar with the department's work to combat Medicare and Medicaid fraud, military procurement fraud, and illegal offshore tax shelters, and you will see more such cases in the future. We are complementing those efforts with others that have not received as much public attention. One example is the Employment Tax Initiative, which seeks to punish people who fraudulently fail to pay payroll taxes. Employment tax violations represent tens of billions of dollars in lost revenue to the U.S. Treasury. A second example, which has resulted in multiple criminal convictions over the past year, is the work of our Environmental Crimes Unit of the Environment and Natural Resources Division to prosecute perpetrators of fraudulent transactions involving tax credits for renewable fuels. Our white-collar enforcement is also becoming smarter and more efficient thanks to the use of technology to detect and uncover fraud. We use sophisticated data analytics in a number of the department's major healthcare fraud cases, including recent cases brought by the Healthcare Fraud Unit of the Criminal Division and by our Medicare fraud strike forces around the country. The department is building on that success. We think that's a very effective model, and so we're using it in opioid abuse. We're hiring data analysts to support the opioid fraud and detection unit. In addition, we're using data analytics to more quickly identify, investigate, and prosecute manipulations of the securities markets and other forms of fraud that threaten the integrity of America's financial system. In January, the Antitrust Division secured a guilty plea by the U.S. arm of a large European bank for price fixing with emerging market currencies. The same month, department prosecutors charged 8 individuals for manipulating futures markets. It was the largest futures market criminal enforcement action in history. Most of the cases involve schemes termed spoofing. Spoofing refers to the illegal practice of placing an order for a futures contract that the trader does not intend to execute. We will continue to work with regulators, including the Commodity Futures Trading Commission and the Securities and Exchange Commission, to identify and aggressively prosecute manipulation and trading schemes. Another point that I want to make about the department's white-collar enforcement is our ability to adapt to the types of criminal conduct normally considered as white-collar. Drug trafficking and national security investigations, for example, frequently involve sophisticated data analysis and complex financial transactions. Criminal schemes use the internet and other telecommunication systems, technology, business supply chains, and international financial networks, all of which call on us to employ traditional white-collar investigative techniques. A few weeks ago, the Criminal Division's Organized Crime and Gang Section and the Nevada U.S. Attorney's Office charged 36 defendants for their alleged role in a transnational racketeering enterprise via an internet forum known as InFraud. The organization represents the latest in a pattern of new cybercriminal enterprises that facilitate the large-scale acquisition, sale, and distribution of stolen identity and financial information. And the conspirators also use digital currency. Our recent press releases reveal many cases involving transnational organized crime and digital evidence. The U.S. Attorney's Office in California's Eastern District played a major role in a takedown last summer of Alpha Bay, which was the largest criminal marketplace on the internet. That case, which also involved a stellar team from the Computer Crime and Intellectual Property section of the Criminal Division and agents from the FBI and DEA, melded narcotics and drug trafficking and cyber and white-collar crime. Just last month, our money laundering and asset recovery section, along with assistant U.S. attorneys here in the Southern District of California, secured a guilty plea in a major banking investigation. The bank ignored evidence that customer transactions were related to international narcotics and money laundering activities. In those cases and others, the department scrutinizes not only the people who buy, sell, and use illegal drugs, but also the flow of money and resources to support those enterprises. We ask this question: which people and organizations provided the necessary goods and services to the criminal enterprises? And then we seek to hold them accountable for any criminal violations. American corporations increasingly devote resources to compliance and oversight efforts designed to deter crime. We recognize that most American corporations are looking for ways to ensure that they comply with the law, not to violate it. They take proactive steps to protect their brands. Some forward-thinking leaders contact department officials and our law enforcement partners with ideas about how best to mitigate risk. And we welcome input from good corporate citizens. Protecting our nation and maintaining the integrity of our financial systems requires strong relationships between law enforcement and American business. Our department is committed to reinforcing and promoting those ties. Last June, the Attorney General announced that the department would no longer direct third-party settlement payments to private entities that were not harmed by the defendant's conduct. In mid-November, the Attorney General restricted the department's use of agency guidance to impose requirements beyond those dictated by law and duly promulgated regulations. In late November, we announced a new Foreign Corrupt Practices Act enforcement policy, and that FCPA policy was incorporated into our U.S. Attorney's Manual. Now, there is a long tradition of Deputy Attorneys General issuing white-collar policies in memoranda that are named for the deputy. You've all seen these over the years. We had the Holder memo and the Phillip memo and the Yates memo. I forewent the opportunity to issue a Rosenstein memo, at least on that issue. Memos can be useful in explaining a new department policy or initiative, but they do carry drawbacks. One problem is that it's difficult for prosecutors to keep track of what memos are in effect. A few years ago, the volume of memos about drug enforcement became so overwhelming that prosecutors resorted to public internet searches to try to find the latest version of the policy. Another problem is that the memos create uncertainty for businesses and other third parties who wonder whether new department leaders will continue to embrace policies named for their predecessors. Uncertainty makes it harder for businesses to make informed decisions. So I try to avoid issuing memos, and my office is conducting a large-scale project to consolidate all existing department guidance into the U.S. Attorney's Manual. So we'll have a single source, a compilation of all department policies that our folks will know and that you'll be able to identify in the U.S. Attorney's Manual. Now, corporate America is often the first line of defense for detecting and deterring fraud. Meaningful compliance measures help our department conserve its finite resources. And we want to reward companies that invest in strong, effective compliance measures. The challenge of ensuring compliance is especially acute in large and diverse organizations. And I can empathize, because as Deputy Attorney General, I reflect every day on the challenges that we face with 115,000 employees of the Department of Justice. Things go wrong in every organization. But when something does go wrong, the greatest consideration should be given to companies that do not just adopt written compliance programs, but incorporate them into corporate culture and message from the top that compliance is an important corporate value. If you want us to treat a corporate entity like a victim when a corporate employee engages in criminal conduct, you should act like a victim who wants to see the perpetrators held accountable. Finally, let me conclude by noting that principled disagreement, such as between prosecutors and defense attorneys, is essential in a democracy. One of the most frequently quoted remarks mocking lawyers is from William Shakespeare's play Henry VI. You all know the line. The first thing we do, let's kill all the lawyers. Now, Shakespeare did not mean that literally. On the contrary, the speaker is a criminal. His point is that without lawyers, nobody would need to follow the law. That would be good for criminals, but it would be bad for a society founded on the rule of law. In a time of strong political passions, lawyers have a special responsibility to demonstrate why law and logic are essential to the peaceful resolution of disputes. And to succeed in that endeavor, we need your input and support. So I hope that you will use opportunities like this conference to share your thoughts with us. We have a number of federal prosecutors who are here among you, and we look forward to your feedback about any issues that are relevant to your practice. So I look forward to continuing that interaction with you in the future. And in Washington, if we all make it back, those of us who are from the East Coast, and I greatly appreciate the opportunity to speak with you here this morning. Thank you very much.